Good morning, everyone. On behalf of Hector De La Salle, welcome to the Appellate Division, sitting in and for the Second Judicial Department. The judges that will be hearing the appeals today and then deciding them are, to my right, the Honorable William Ford from Suffolk County. To my left, the Honorable Deborah Dowling from here in Kings County. To my far right, the Honorable Susan Quirk from Kings County. And my name is Mark Dillon from Westchester. And we're also joined today by Kristen Strank, who is one of the clerks of our court, and she will be calling the calendar in a few moments.
Thank you, Your Honor.
Thank you all. Number 8, Collins versus Denaro, to be followed by number 10, Maddox.
Morning, Your Honor. May my partner join me at the table?
I'm sorry?
May my partner join me at the table,
Yes.
Your Honor? Thank you.
Good morning, esteemed
Good
justices.
morning.
My name is Avi Cohn, and I was the trial attorney for the appellant in this case, Frank Denaro. I thank you for allowing me a few minutes to speak and argue before you today. Your Honors, in my humble opinion, affirming this verdict poses significant threat to the integrity of our legal system, and if upheld, this case could actually set a very, very dangerous precedent, allowing any dissatisfied heir to challenge an inheritance merely on the basis of personal dissatisfaction without the necessity of presenting concrete evidence
You're going
of
to burden
undue
of proof.
influence. I'm sorry?
You're going to burden of proof.
I'm going to burden of
All right,
proof.
I'm sorry to interrupt, but go on.
Sure, Your Honor. The evidence in this case was woefully insufficient. The motion for directed verdict and the motion for renewed motion for directed verdict and motion to set aside the verdict should have been granted, as Justice Steinman himself actually wavered on the record, and he actually, when I made that motion, he said that the evidence showed that there was only circumstantial evidence presented by the plaintiff in that case, which Mr. Cohan, who's going to get up here and tell you that there was a whole lot of evidence, but that is buttressed by his actual arguments in his brief, where he says that he doesn't have to show all the acts constituting undue influence as long as he showed some level of motive and intent.
Circumstantial evidence can, generally speaking, be sufficient to show undue influence as long as it's substantial enough, right?
Correct, but there was none. And in my opinion, the jury reached the verdict that they did based on one piece of evidence which Judge Steinman allowed into evidence.
Counsel, that's the October 13th letter.
Correct.
Okay, it's your position that it should not have been allowed into evidence.
Absolutely not.
Was it ever properly authenticated?
No, it was not. It was not, and that was exhibit number 2 and exhibit number 12, which was later in a letter from purportedly written by the decedent to Senator at the time, Senator Clinton, to compare the handwriting. There was no expert used by the plaintiff to compare handwriting. It was just basically the plaintiff saying, this is my dad's handwriting. The plaintiff could have very easily, and she found it conveniently in her belongings before the trial started. We believe that she wrote this letter and she tainted the jury, and Judge Steinman should not have allowed that letter into evidence.
Counsel, there's no proof of that.
There's no
proof that she wrote the letter or that she forged this letter.
It was in her possession. It wasn't properly authenticated.
What about the letter be admitting to show the decedent's state of mind?
That was the letter, Your Honor. And all that letter actually says is that I wish that my children divide everything 50-50 or something to that effect. That is contrary to everything else that has taken place throughout the years. And this is just as a reminder, Your Honors, since I know that you're familiar with this case, the plaintiff was estranged from her father for about 8 years. And during that time...
Yeah, we know the facts. And they came into contact after Hurricane Sandy.
Absolutely. And for what it's worth, and just going back to the standard, Your Honor, there was Nicholas Denaro, by all indications, was independent financially, emotionally, socially. He was 97. He lived alone. He drove by himself. The plaintiff testified that she'd not witnessed any alleged conduct. And she actually said at the trial, when I asked her what the undue influence is, she answered, quote, "I guess we have to wait for the trial to finish to come to a conclusion." I don't know what that means, and I don't know how Judge Steinman allowed that to further the argument, but this should have been dismissed from the get-go.
Counsel, why is there no confidential relationship between your client and his father?
Because, Your Honor, the case law, which I brought up in my brief extensively, shows that there is no, just by the mere fact that a family member serves as a healthcare proxy or a power of attorney, does not create a relationship, a confidential relationship. To that end, the plaintiff was also interested in becoming a healthcare proxy, but she said she thinks that my client, the appellant, was more equipped to be the healthcare proxy. Everything was done at arm's length. The decedent was investing in his own properties throughout, and that was one of the documents that was moved into evidence, his own dealings, and for some reason, that was not taken into consideration by the court, and it should have been, because he was completely independent. He actually signed a DNR, a do not resuscitate, in front of his doctor 3 weeks after the alleged TOD, the transfer on death, was changed back to my client.
Well, his sister was there, too.
His sister was there,
You
too.
need to be a witness.
And that goes to the competency and the fact that the decedent did not suffer from any sort of mental incompetence at the time. He was not unduly.
I think that both sides agreed that the dad was in fact in possession of his mental faculties, that was not an issue, that he lived alone, he didn't have an aide to assist him, that he was in fact independent. The question then becomes, and I know that there was an event where the plaintiff in fact alleged that the dad had changed some of the information on other accounts, and that when the dad allegedly found out, he, had the defendant call the bank and had it changed back to what his desires allegedly were. So I don't think there's an issue as to that in terms of whether in fact your client exerted undue influence. I believe that there's testimony in the record that both parties assisted him with things like, going to the doctor or maybe his senior center or things like that.
And
I don't know whether there was anything else that would tip the scales.
so, Your Honor, that's a very good point. And to that end, I want to point to you Justice Steinman's inconsistent ruling, where he said with regard to the Chase account, he said that the evidence showed that Nicholas, quote, knowingly and voluntarily, without undue influence, changed the Chase account to a joint account, end quote. How could he have known that? So how is it that Nicholas DeNaro did certain things that were on his own without any undue influence, but then the same exact things were alleged and there was a finding that there was undue influence there? That must be, this ruling itself goes to the heart of...
Counsel, it sounds like that goes to the weight of the evidence that was presented to the jury, right?
Well, it's inconsistent, Your Honor. It's inconsistent, and for
So
what
it's your position that that's insufficient to show what the plaintiff was looking to show.
Absolutely, and Your Honor, I also want to reference Inra Walters, which is the Court of Appeals case, which my understanding is it's still good law, and that case specifically said that it must be shown that undue influence exercise amounted to, quote, a moral coercion which restrained independent action and destroyed free agency, or which by importunity which could not be resisted, end quote. So there was no showing of moral coercion here. And the case law is very clear that just by the mere fact that somebody is unhappy with a bequest or devisement does not mean that it's undue influence. The case law is very clear from this own department. So the fact that Judge Steinman did not grant the directed verdict is contrary to Inrich Hinberg's will, which also says that the burden of proof always rests with the contestant. The fact that the burden of proof was somehow shifted to my client to disprove undue influence is flat out incorrect
Well,
and contrary
that's
to the
correct
law.
if there's a confidential relationship.
If there's a confidential relationship, which did not exist, Your Honor, it should not have gone to the jury. The fact that also there were bank accounts which were rendered voided in Judge Steinman's decision after the fact, 10 or 20 years after the fact, just is implausible because these were joint tenancy with rights of survivorship. It goes against the premise of New York Banking Law 675, which says that, if you are a joint tenant, it automatically passes to the other. So that Judge Steinman undid that is basically rewriting legislation, and that's unacceptable. It should be unacceptable to Your Honors.
Thank you, Mr. Cohen.
Good morning. May it please the Court, Your Honors. My name is Michael Cohen from Cohen Law Group, and I represent the plaintiff respondent, Joan Collins, and I, too, was the trial attorney in the court below. Your Honors, the decision below should be affirmed in all respects. I'm going to spend most of my time addressing what the appellant said. I don't want to rehash my own brief entirely. We're not asking this court to set any crazy new precedent, to issue any new law. We're asking, this is a fact-specific inquiry for this case only. And in this case, and I fully appreciate that it is usually not easy to prove undue influence, but it doesn't mean it can never be proven. And in this case, it was especially important that a jury found that it was undue influence. Now,
Counsel,
can we start?
I'm sorry.
I was going to ask if you could start with confidential relationship,
Sure.
because it seems as if we have to first look at that, it's yes or no, and then we know where the burden to proof falls.
sure. So the case law does say that if there is a confidential relationship between the recipient of monies from the decedent, between him and or her and the decedent, then the burden shifts to the recipient to show that the transaction was fair and there was no foul play.
Confidential relationship.
Right, and in this case, you had it in so many cases. You had a 2005 power of attorney and a 2707 power of attorney, both of which were used to make transfers out of the decedent's bank accounts. When he called the bank accounts with the decedent, and there's the banks with the decedent, there's recordings on file in the record where he referenced his POA. When he
Counsel,
called.
where's the case law that says because you're a power of attorney, it makes it a confidential relationship?
So the Hennick versus Darkhan Second Department, 2020, from this court, discusses the shifting of the burden.
Not the shifting of the burden. Because he signed a power of attorney or he was his father's power of attorney, how is there a confidential relationship? There's case law that states that a power of attorney equates to a confidential relationship?
Well, it's not a power of attorney in and of itself, Your Honor. It is a confidential fiduciary relationship.
Okay, so tell us, because your client concedes that there was no mental impairment. The dad was mostly independent at 97 years old. So how was there a confidential relationship? What proof do you have?
So it's the power of attorney. He was the trustee of his trust. He administered the trust for the decedent's home.
So you're saying his involvement in the finances of the dad were enough to create this confidential relationship? Is that what your position
It was
is?
not just the finances. He was a healthcare proxy, and there's ample evidence in the record that he used his healthcare proxy to make medical decisions on behalf of his father. He was not entirely independent, and we never acknowledged that. In fact, he was incredibly dependent on Frank because he was his power of attorney agent, because he was the trustee was after. But
So he was dependent enough to make your client a 50-50 beneficiary, but he wasn't dependent enough to make the other side.
That's a very good question.
You're contradicting yourself.
No, it's a very good question. But the difference is when my client got that 50-50 beneficiary status, she didn't put her email address and her phone number as being that of the decedent like they did.
Counsel, it was 2 weeks before. There was 2 weeks' time in between.
No, I understand, but there was no misrepresentation by her as to the contact information for the decedent, and that's part of the undue influence we're claiming. Also, it was 50-50. If my client wanted to engage in undue influence, she would have made it 100-0. She was not involved in that. And if you listen to the recordings, there's a big difference in the recordings. The recordings with my client and the decedent calling the banks, my client says, I don't want to talk. I want him to talk for himself. I just dialed the number for him. If you listen to the recordings with Dreyfus, with Mr. De Niro, he completely takes control of the conversation, interrupts his father when he asked to see a copy of what he signed. He says, no, we don't want to do that, Dad. Joan is going to see it somehow. And in another phone recording, he refused to take a message on behalf of his father. He said, no, that's okay. I don't need to give him a message. And even if reasonable people can disagree whether there was undue influence here, and this is where Justice Ford's comment comes into play, this is a weight of the evidence issue. The standard under Cohen versus Hallmark is whether the jury's verdict was so irrational based on the evidence presented that no rational jury could have reached that verdict. And whether you agree or disagree with the weight of the evidence, a rational jury could have found this. And, there was mentioned that there was not evidence in this case.
So let me interrupt you for a minute, and certainly I'll allow you to finish making your point. But the fact that there was a letter that was introduced by your client, which certainly seemed to indicate that the father wanted to divide his estate 50-50, but there was no authentication of that document other than your client's testimony. That could weigh or tip the jury's determination as to what should occur in this case.
That is actually not entirely correct, Your Honor, because the appellant testified that that was his father's handwriting on that 2013 handwritten note.
I think he said it looks like it, but I don't think he said it was.
He was asked a second time, and he stated more definitively that he thought it was father's. That's page 375 of the record. And also when we showed the letter to then Senator Hillary Clinton, it was authenticated by that other letter where appellant also said it was his father's handwriting. And if you look at both letters, they're in evidence. It's clear that they're written by the same person. And there's nothing in the record where it was claimed that my client wrote the letter. He's saying that now for the first time. If there's a cite to the record, I would love to hear it. They mentioned estrangement. The estrangement was because of the appellant, and that started in 2005 when the mother passed away, Bridget De Niro. And Frank, the appellant, alienated my client, told her that if she was to contact the father ever again, that he would call CPS on her. And
We're aware of that, but
Yes.
certainly there was an issue. There was some testimony as to the fact that your client and the father, the deceased father, had a contentious relationship, that there was a lot of arguing between the two. And I also am aware, and we are aware, that the defendant certainly indicates that he was concerned about an escalating situation between the father and your client as to, certain things being done within the context of water being poured in a mailbox, et cetera, et cetera. But certainly it would appear that there was testimony in the record as to the nature of the relationship between the two that might have impacted the father's determination in this particular proceeding.
And that was because of Frank's actions. And let's take that to its logical conclusion, Your Honor. That may have been why he initially had everything go to his son. But when they reconciled in 2012, that was a natural, the 50-50 designation that post-dated, that was a natural result of that reconciliation, as was the rest of his testamentary intent from that time forward, including the 2013 will and the 2015 trust. Everything was 50-50. Suddenly, he changed his mind in those 2 weeks and decided to go back to 100-0. And I just want to mention, this decedent was not independent. In fact, pages 372 and 373 of the record, there's evidence. There's a note in evidence, and he threatened to put his father in a home if he ever called 911 again, because the father kept calling 911 when there was no emergency. So he was not independent. The other indicia of undue influence is he typed notarized letters, the appellant did, on behalf of the father, supposedly, after the 100-0 designations went back into effect, the most recent ones, where he reiterated the same thing that was already in the designation, and he testified and he admitted that the banks never requested or required these letters. So he was doing extra things to solidify and cement his 100% designation that he had the father engage in.
Last point.
Yeah. The last point on the independence, he was not independent. He also, the appellant, and there's evidence in the record, I could give the page numbers, he had the statements from Dreyfus and TD start going to his own mailing address rather than his father's, and he changed them to email, electronic delivery, instead of going directly to his father. And that's consistent with the undue influence he engaged in when he put his contact information on the most recent 100-0 designation form. May I just address the 4402 motion that was made at trial briefly?
Sure.
The motion was made after the verdict was already rendered, and under 4402, it's untimely and it should be rejected just for that reason. There was an issue about 2 exhibits and whether they were in evidence or not, and there's evidence in the record, pages 827 to 835, where the judge asked the court reporter, is this evidence sheet correct? Were exhibits 7 and 8 in evidence? And the court reporter on the record said, no, they are not in evidence. And the judge correctly said, even if somehow they were to be in evidence, those 2 exhibits, which were 2005 designations going to the father entirely, going to the son entirely upon death, it was harmless error because the jury, through testimony, already knew that the father was giving 100% to the son back in 2005.
All right. Thank you, Mr. Cohen.
Thank you, Your Honor. I rest my brief.
Very briefly,
Not if it's a rebuttal. Again, the rules are no rebuttal. If there was something that was wrongly stated about the record, we'll allow it.
well, yeah, my client never testified that it was his handwriting. He just never did that. That's flat out wrong. The 2 exhibits, there was actually checked off that it was in evidence. The fact that it didn't make it to the jury pool, and Mr. Cohen actually acknowledged on the record that he took the exhibits and it was with him in his office. So, thank you.
Thank you both.